welcome to the afternoon session of the King's Chambers Property Team's Pick and Mix for 2021. We're halfway through the day now. So far we've had Leslie Anderson, QC, talking about service charges. We've had Nigel Clayton on mediation. We've had Mark Harper, QC, talking about experts. And we've just had Paul Lakin dealing with prescriptive claims. It's my turn now to talk about commercial rent arrears in the context of COVID. Now, I advised on a few of these before there was any case law. Now, as we sit here in December, we've got 3 High Court cases, and it's been good to see how these issues have played out. It's been even better, I suppose, to see that I'm unlikely to get sued, because it looks like my advice was right when I was doing it. So it's fair to say that 2021 was shaping up to be a really good year for landlords chasing rent arrears through court action. 3-0 to the landlords represents those 3 High Court decisions, all of which went in favour of the landlord. It's also an excuse for me to use a photo of Paul Mullin scoring for Wrexham. I say 3-0 to the landlords. In fact, the Bank of New York and Cine-UK case involved 3 joined cases. So, in fact, it's really 5-0 to the landlords. So, to labour the metaphor even further, it felt like we'd got to the 89th minute. The landlords are leading 3-0, 5-0. Potential defences have been blown away. And then, hold on a minute, suddenly on the 8th of November, the government published the commercial rent coronavirus bill, which suddenly made everyone wonder whether all of this work by landlords has been in vain. Now, many of you will know that in essence, the bill provides for binding arbitration in relation to certain unpaid commercial rent arrears. Does that mean, though, that all of those gains made by the landlords over the last year have been in vain? Are those cases still relevant? And the answer to that is yes, they are still relevant. Not all rent debts will fall within the ambit of the bill. The question, is there a rent debt at all? Now, but for those cases, then at this arbitration stage, it may well be that tenants will be saying, actually, there's just no debt because I have a valid defence to the landlord's claim for rent arrears. That will be much harder for tenants to do now as a result of that case law. The bill provides limitations on the dates as to when relevant rent liability must accrue for it to fall within its compass. It also provides limitations on the type of COVID restrictions which are relevant for the purposes of the bill. It also provides that it will only apply to tenancies falling within the scope of the 1954 Act. Those tenancies which fall outside the ambit of the bill, there's an updated voluntary code. I'm not going to go into that today. The time just doesn't allow that. So what am I going to talk about? Well, I'm going to talk about the defences which were raised by the tenants in those 3 cases, and I'm going to provide an overview of the bill. In relation to the bill, I'm not going to be going through it line by line. I'm not going to go through the detailed workings of it. It is only a bill at this stage, and it seems to me that at least some changes are reasonably likely to happen by the time it gets enacted. So there's not a great deal of point in spending a long time looking at the detail. Now, across the 3 cases, an enormous number of defences were raised by the tenants. I'm going to whip through most of them and spend a little longer talking about the more important ones. And as you can see here, I've grouped some of them together. but we've got 8 separate categories of defences that were raised across these 3 cases, and it really is quite striking that such a number of defences were raised across in relation to what amounts to 5 separate leases, and in each case, summary judgment was granted in favour of the landlord, which gives you a flavour of how strong the landlord's position was. So the first defence that's raised is a failure to follow the code. That's the code of practice for commercial property relationships during the COVID-19 pandemic, rather than the Green Cross Code. It was a point that was raised by way of defence in the TFS and in the Cine-UK cases. Essentially, it was said that because the landlords in those cases hadn't, it was claimed, engaged properly with the code, hadn't negotiated with the tenant, that provides a defence. Alternatively, it was said to be a compelling reason for the case to go to trial rather than be dealt with at a summary stage, and that was rejected pretty easily. The code is voluntary, expressly says it doesn't impact on the parties' substantive rights, and so there's no reason why the court shouldn't grasp the nettle and give summary judgment. I'm going to deal with this one very quickly too. This was a slightly unusual argument raised in the TFS case, where it said that what we had in terms of COVID type protection for commercial tenants, so you had a range of measures. You had the restrictions on winding tenants up, you had the restrictions on forfeiting for non-payment of rent, you had the restrictions on commercial rent arrears recovery procedures. And so as a result of that, it was said that it was somehow inappropriate in going behind those restrictions for the landlord to sue for the rent. That was just rejected fairly easily by the High Court on the basis that, well, if there is no restriction on the landlord doing this, why shouldn't the landlord do this? The landlord can just rely upon the landlord's rights, and in the absence of any statutory restriction, the landlord is entitled to come to court and claim the rent. This one is an important one. I'm going to be talking about rent cesser clauses a fair bit over the next half hour, which I'm sure you can't wait to hear. The typical rent cesser clause, I'm just going to refer to the one in Cine-UK. So that says that in case the property or access thereto shall at any time during the term be destroyed or damaged by any of the insured risks so as to render the property unfit for occupation or use, then the rent and service charge shall from the date, blah, blah, be suspended and cease to be payable until the property is fit for occupation again. Now, the argument here was that because loss of rent was an insured risk within the lease, and because there was an argument to say that the closure regulations, the coronavirus closure regulations, could at a stretch be described as damage to the premises, then the rent cesser clause was engaged. So from the point when the property can't be occupied until the time when it's available to be occupied again. And it is said that an attempt was made to shoehorn COVID arrears into the express rent cesser clause. So what you need to do is to construe the cesser clause. When is it engaged? And what we can see across the various leases involved in this case was that the judge thought, no, in fact, on as a matter of construction, these clauses dealt with physical damage, physical destruction, either to the premises or to access to the premises. There was nothing in the cesser clause that would allow for rent to be suspended in the event of a legal restriction on use of the demise. So as a result of that, it was fairly straightforward to knock out the claims based on express rent cesser clauses. However, it does need to be borne in mind that although in these cases that's what the result was, each case will turn on its own facts, and so every lease might have different wording, and it's entirely possible for a given lease to have, in fact, you do see them from time to time, a given lease to have a rent cesser clause which is triggered by a legal obligation not to use the premises, just not in these particular cases. So if that's express rent cesser clauses, what about implied rent cesser clauses? And that was the major focus of the Trocadero case. And the implied term that was contended for by the tenant in Trocadero is set out there. So if the permitted use of the premises by the tenant under the lease were to become illegal, then the obligation to pay rents and service charges otherwise due would be suspended and cease to be payable for that period. Remember that one of the things that can undermine an argument based on an implied term is a failure to, or an inability to properly plead what the term is that you are trying to rely on. Too often we see cases where people talk in very general terms about implied terms without properly setting out what it is they're talking about. In the Trocadero case, they had some wording that they were relying on. So when we're looking at implied terms, in the COVID context with rent arrears, we still need to go back to the old cases dealing with implication of terms, so officious bystander and all of that. As far as that is concerned, it's necessary but not sufficient that the term has to be fair, reasonable and equitable. And here the judge thought that it would be fair, reasonable and equitable to have an implied term like this. There's nothing offensive about it. The term then has to be obvious, or it has to be required as a matter of business efficacy. Now, is this implied term obvious? And what the court did here was to look at the existing rent cesser clause in the Trocadero case. And what the court said was, well, look, the parties have expressly considered, they put their mind to circumstances in which the rent won't be payable as a result of something happening. Certain things such as damage or destruction of the premises themselves. So if the parties have put their mind to it and thought about what would happen to the rent and thought about circumstances which would trigger a suspension of the rent, how can it be said that it's obvious that they would have wanted something like COVID to trigger it too? So that aspect of the way in which the claim was put was rejected. What about business efficacy? Well, the question there is whether, without the term, the contract would lack commercial or practical coherence. So it's a tough test to satisfy that. And at one level, when you're looking at whether the lease lacked commercial coherence in the absence of this sort of term, if you think about this, the Trocadero is a case about a cinema. And it was the cinema in the Trocadero centre. The purpose of the lease was for the operation of a cinema. It was a lease of a cinema, and it had to be used as a cinema. The idea of paying rent at a time when it couldn't be used as a cinema, or indeed at all, could it be said to lack commercial coherence? It feels wrong at first glance. However, what the judge said in that case is that you need to think about the allocation of risk with this. Because without the implied term, the risk of a legal obligation preventing the tenant from using the premises is shouldered by the tenant. There's no good reason why that loss should be borne by the landlord. What's good for one is good for the other. And so it can't be said that it lacks commercial coherence for the tenant to bear that risk rather than the landlord. So as a result of that, this argument based on an implied rent cesser clause was rejected too. What the judge really said was that it's a matter for negotiation between the parties as to where the risk should lie. And that really sums up the point. He's saying that at the time the lease is originally being negotiated, it's open to the parties to negotiate a narrow or a wide rent cesser clause. according to their bargaining positions and the way in which they want to allocate the risk of something going wrong. And so that's why the cesser clause is so important in these cases. I'm going to take this defence briefly too. Raised in the TFS and in the Cine-UK cases, it was said that the landlord was in breach by failing to insure against the COVID loss of rent. But in order for the landlord to be in breach, there has to be an obligation on the landlord in the first place, and there was no obligation on the landlord in these cases to insure against these losses. Just because a landlord is entitled to insure against this kind of loss doesn't mean it's obliged to. And you look for clues again, broken record, the rent cesser clause. What does that say about rent suspensions? And so in this case, there's nothing to indicate that there was any obligation on the landlord to insure against these forms of losses. And so without an obligation, there could be no breach. Again, taking this one very briefly now, the principle in the Mark Rowlands and Bernie Inns case is that if a landlord, as a matter of fact, takes out an insurance policy that covers a particular risk, and as a matter of fact is paid out under that policy, then the landlord, or as in the Mark Rowlands case, the insurer on a subrogated basis, shouldn't be able to claim the same loss against the tenant because that's double recovery. Now, what this argument needs is you need to consider the terms of the policy to see what it in fact covers, and you need to look at the terms of the lease. And so what the court said in Cine-UK here was that the landlord is insured against losses, and absent tenant insolvency, the landlord would only suffer a loss if the tenant wasn't required to pay the rent through the rent cesser clause being triggered. If the rent cesser clause covers COVID-related non-payment of rent, so the tenant can say, I'm not paying this, I'm entitled not to pay this because of the cesser clause, then the landlord suffers a loss which the landlord can claim on the insurance. But if the cesser clause doesn't say that, then the tenant is required to pay the rent. And if the tenant is required to pay the rent, then the landlord suffers no loss and so won't get a payout from the insurer, and the principal won't be engaged. The sixth form of defence raised, this time in Cine-UK, supervening event or illegality. Again, taking it very briefly, it was said that the occupation and trading from the premises would be illegal because it would be in breach of the coronavirus regulations. Now, that may be right, but the principle of illegality here is directed at relieving a party of performance if performance of a particular obligation would be illegal. And the performance in this case would be performance of the obligation to pay the rent, and there's nothing illegal about paying the rent. Hence, this principle didn't avail the tenant. Frustration and temporary frustration. I remember about 18 months or so ago, the property world was terribly excited at the thought of frustration in the context of COVID. It seems to have fizzled out. Raised in the Cine-UK case here, the judge was prepared to accept as a matter of principle that the COVID regulations could constitute a frustrating event, but held that on the facts, based on the length of time, the term of the lease, the limited period of the restrictions, and the remainder of the term, that there was no frustration in fact. It was also suggested that there might be something called temporary frustration, so suspending the contract rather than terminating it, with the effect that for the duration of that suspension, there would be no rent payable. And the court just said, no, there's no such thing as temporary frustration. Frustration terminates a contract. It doesn't temporarily suspend it. And the final defence that was raised and rejected was raised to some extent in Cine-UK, but principally in the Trocadero case, failure of basis. So if parties contract on a certain basis, and if the basis is so fundamental to the contract and it then fails, it can give rise to a restitutionary claim. The argument here was that this was a cinema lease, and if it can't be used as a cinema, the whole basis of the contract has fallen away, and that rent shouldn't therefore be payable. And it's quite an interesting decision, the way in which the judge deals with this and the argument. It'll be interesting to see what happens in the Court of Appeal on this, because the Trocadero is one that we're told is likely to go on appeal. So what the judge said was that the use of the premises as a cinema was not fundamental to the basis on which the parties entered into the lease. It was merely what they expected would happen. And what you have to do when you're assessing this point is to look at the allocation of risk between the parties to see if either party has assumed the risk of this dreaded thing happening. What the judge said was that you can't assume that these premises, and the parties didn't assume that these premises would, come what may, always be open and available for use as a cinema. We know that because premises sometimes, for example, burn down. And when premises burn down, they're unavailable for use. And when they burn down, what's the first thing you do? You look at the rent cesser clause. And so again, the importance of those clauses to these arguments comes to the fore here. We look at the insurance clauses, we look at the rent cesser clauses, and they indicate how the parties are taken to have allocated the risk of an inability to use the premises in the event that something goes wrong. And what they showed in the Trocadero case was that there would be a rent suspension in some, but not all circumstances. So the parties passed the risk of those other circumstances happening to the tenant. There was also an express term whereby the landlord said, I'm giving you no warranty that these premises can lawfully be used for the permitted purpose. And that was relied upon quite strongly by the judge. Now, it'll be interesting to see what might happen on a different case if that particular clause doesn't appear in another lease. It may be that was what made the difference between success and failure for the tenants. So that's one to watch out for in future. So overall, these are three very strong cases at High Court level favouring landlords. One, possibly two of them, Trocadero and Cine-UK, are to go on appeal. So we don't yet know whether this is the final word. They're strong, as not just because they cover 5 separate leases and such a multitude of defences, but they were all knocked out on a summary judgment level. So each judge was sure enough of the strength of the landlord's entitlement to the rent that he was prepared to give summary judgment. Bear in mind always, though, that just because a particular argument failed in one case, it won't always fail in other cases. Everything depends on the particular wording of the particular lease. So that's where we got to by the 7th of November. And on the 8th of November, we were hit with publication of the bill. So by way of introduction to it, where are we at the moment? Well, just over a week or so ago, 2 weeks ago, in fact, now, we passed, the bill passed its second reading in the Commons. The committee stage is where it's at now, and that's scheduled to complete in the next week. It's clear from reading Hansard, as I did, lucky me, of the second reading, that there's cross-party support for the principle of the bill. Labour supports the principle, the Lib Dems support the principle. But it's also clear from reading Hansard that there are significant questions that these opposing parties have in relation to the detail. The detail of the bill may well change by the time it's enacted, so we need to be aware of it, we need to prepare for it as lawyers, but we can't treat the bill as being set in stone. In essence, as I say there, This is to be a binding arbitration for 54 Act tenancies, where the rent arrears have accrued during periods where the tenant is subject to mandatory COVID closures. Now, as I've said, I'm not going to go through this in detail line by line. I'm going to pick out the key aspects and certain themes from it. So there are detailed provisions in the bill as to which precise debts are covered as protected rent debts. They relate primarily to businesses and premises closed down, not exclusively, by coronavirus regulations. They don't apply, for example, to businesses that have been affected by a drop-off in footfall as a result of changes of behaviour or other restrictions. They apply to rent accruing at particular periods. That will vary sector to sector because, for example, pubs might have been open or rather required to close for periods that are different from, say, cinemas and clubs. The bill is time limited, so if you want to arbitrate your rent debt, your protected rent debt, then you need to do it within 6 months of the bill being passed, whenever that may be. It's scheduled to be in the new year. There are detailed mechanics provided as to the various stages as the arbitration progresses. The time limits are fairly tight, 14 days, but they are extendable with agreement or by order of the arbitrator. Now, the arbitrator's jurisdiction is in a sense only engaged at the point, or rather the jurisdiction to make an award is only engaged if he or she considers that the tenant's business is viable, either generally or if an award were to be made. So that's a gateway test, really. Viability is something that is the big unknown as far as the bill is concerned. The guidance notes, which were published alongside the bill, don't guide at all in relation to this. So we're all pretty much in the dark as to what this might mean. But if the arbitrator considers that the tenant's business is or will be viable, then the relief that can be granted by way of award is flexible. I've set out there the ways in which the arbitrator can make an award by writing off the debt in whole or in part, extending time, giving instalments over a 2-year period, or dealing with interest. No costs orders. Now, this is going to be of considerable concern, I would have thought, to certain parties. There could be an enormous amount of work involved in fighting one of these arbitrations, an enormous inquiry into viability or into solvency. There could be the need for an oral hearing. There could be a need for cross-examination if there's a suggestion that one party is manipulating its financial position to convey a sense of a risk of insolvency, or to convey a sense of difficulties in terms of viability. But there's no cost orders other than in relation to arbitrators' fees. Appeals are governed by the Arbitration Act. There's a moratorium. I'm not going to go through the detail of this, but various moratoriums, or moratoria, I'm not sure, in relation to other remedies. The idea is that the arbitration should be the primary route for the parties where there is an issue, where there are these arrears. Now, the really interesting part of the bill relates to the things called principles and things called proposals. Principles are what guide the award that may be made. So awards are to be made by reference to the principles, and I've set out the two most important ones here. So the award should aim to preserve or restore the viability of the tenant's business, so far as that is consistent with preserving the landlord's solvency. And so far as is consistent with that, the tenant should be required to pay in full and without delay. So the focus is on the tenant's viability and on the landlord's solvency. And if as long as we can preserve viability of business and solvency, the tenant, if we can do that, then the tenant should be required to pay in full and without delay. So if it's a case where the tenant won't pay rather than can't pay, then that should be a straightforward win for the landlord. The award should require the tenant to simply pay up. But in other cases, we get this imbalance between viability and solvency, and this is where it seems to me that the bill is more favourable to tenants than it is to landlords, quite apart from the fact that it puts in place all these hurdles and preventing a landlord from exercising its normal remedies. A tenant doesn't have to show that the rent will tip it into an insolvency situation, although obviously if it can show that, then that would help it to establish the viability point. And as I say, that there's just very little guidance about how we approach viability. It's clear from reading Hansard that the opposition parties are alive to this. I suspect the government is alive to it too, that there are suggestions that the Secretary of State will be publishing some further detail on this in due course. So if those are the principles which underlie the award, how do we get to an award? Well, that's the domain of proposals. So what is envisaged is that there will be sequential exchange of proposals setting out the award that each party will contend for. And at that time, the parties will also exchange evidence going to viability and solvency. What happens then is that once the parties' final proposals have been received, the arbitrator doesn't act in a normal judicial or quasi-judicial function of reading both sides' positions, thinking about it, and then coming to a view as to what he or she thinks is the right answer, or the appropriate answer. The arbitrator's jurisdiction is more constrained than that. It's quite unusual. So if the arbitrator considers that both sides' proposals are consistent, to use the word in the bill, consistent with the principles, then the arbitrator has to choose which one is most consistent with those principles. So landlord says one thing, tenant says the other thing. They're both consistent with the principles, but the arbitrator thinks that, say, the tenant's proposal is more consistent with those principles. The arbitrator has to give the tenants, has to make the award in line with what the tenant has proposed. Can't move from that. If only one proposal is consistent with those principles, the arbitrator has to make an award in line with that proposal. Again, no discretion to move beyond that proposal. And if neither side manages to provide a consistent proposal, then and only then, the arbitrator can decide for himself or herself, but still in line with the principles. So just to end with a couple of unconnected thoughts about this process. The second one there follows on from what I've just been saying about these proposals. It seems to me that parties are going to have to pitch their proposals with great care. This isn't the sort of jurisdiction where it will be a good idea to go in high or to go in low with a view to moving from it in due course. Because if you do that, you run the risk that the arbitrator will think that your proposal isn't consistent with the principles, or is less consistent than the other side's proposal. And they'll just ignore yours from then on, and they will make the order in line with what the other side has proposed. So as a result, I think that probably what lies behind this fairly unusual process is a desire by the government to encourage realism by the parties, and probably as a result of that, to encourage settlements. It may be that not that many cases go to final arbitration. It may be that the process of coming up with a proposal which is consistent with these principles will lead the parties closer together. And I suspect that's what the whole idea of this is. And they can come to an agreement, which then means that there's no need for the arbitration at all. The second thought that I have about this is that there could, in theory, be an enormous amount of disclosure coming the way of one of the parties, particularly. It seems to me from the tenant to the landlord in terms of viability of the tenant's business. The prima facie period for dealing with that and coming up with a counter proposal is 14 days, which isn't a lot of time. So if those time periods remain in the bill when it becomes an act, then it'll be really important to, in advance of this whole process being triggered, try to foster a dialogue and an exchange of information with the other side to get some information and documentation early. And if that fails, then you're into the territory of seeking agreement to an extension or asking the arbitrator to agree it. And that, just 1 minute beyond my scheduled time, is that. I'm going to stop sharing my screen and we'll be happy to answer any questions if any have appeared. Here's a question. So Sarah Carbo says, do you think that where an office was closed but tenants continue to work from home will be covered? Well, the focus is on the effect on the business or the demised premises. So if a business was closed, if the premises were closed, as opposed to choosing to work from home, then yes, I suspect that will be covered. Anna Duffy, hi Anna, what's your view on turnover rent and will this be covered? Well, the definition of rent is pretty wide. I don't think it's turnover rent is mentioned specifically. Service charges, for example, are mentioned. Let me just, rent means an amount consisting of one or more of the following: an amount payable by the tenant to the landlord under the tenancy for possession and use of the premises comprised in the tenancy. So it seems to me that any form of rent would be covered by this. I think that's probably it on the Q&A and on the chat. So thank you very much for your time. If I can just plug the next few sessions on the pick and mix. We've got at 3 o'clock, we've got Dr. Nathan Smith talking about proprietary estoppel, which should be good because that's a really difficult area. At 4 o'clock, we've got Nick Taylor and Ian Cooper talking about possession actions and where we're up to now, because I think there have been some recent changes on that. And then at 5 o'clock, finishing off the best till last, it's Matt Hall, who's talking about, well, his title is What Lies Beneath. So he's talking about things that are, so basically underground things, pipes, septic tanks, basements, mines and minerals. And you'll be looking at that in particular with a view to thinking about the impact that sort of thing can have on development. And with that in mind, I will head off now. So thank you very much. Goodbye.